Morning's docket. That is case number 102421, State of Kansas v. Michael Ramirez.
Good morning, Your Honor. My name is Randall Hodgkinson. I'm appearing this morning on behalf of Michael Ramirez. I request 3 minutes for rebuttal.
3 minutes is granted.
Your Honor, the court granted petition for review on a single issue in this case on whether or not criminal restraint is a lesser included offense of kidnapping. And as this court knows, the Court of Appeals generated 3 separate opinions on that one question. And in fact, I think that question is pretty well fleshed out in those opinions. I don't know that I have a lot to add, except as the court has questions, although I did want to note Judge Atchison's decision on this, the suggestion that maybe criminal restraint is a lesser of kidnapping under 3107-2A as a lesser degree of the crime. That's an intriguing argument. I appreciate it, although that was not one raised in either of the briefs at the Court of Appeals. And so I don't really think that that separate issue was before the Court of Appeals or is before this court. It's an interesting issue.
So even if we determine that it is a lesser degree, which is seductive, as you mentioned, we can't find that it's a lesser included because it wasn't argued? I mean, the issue of whether it's a lesser included is clearly before us, but we're limited to just the specific arguments made?
Well, that seems to be what I hear a lot, Your Honor, that I argued that it was not a lesser included offense under 3107-2B as this court applied it in Widget, and the state in its blue brief responded to that argument.
But that argument is more applicable to a prudential determination, but what we're really talking about here is jurisdiction, because we have a conviction for an uncharged crime, and we've clearly said the court does not have jurisdiction to convict a defendant unless that defendant's been charged with the crime, exception being a lesser included offense. So we're talking about a jurisdictional question, and even if it wasn't argued, we can't find that there was jurisdiction or not jurisdiction. I mean, when we're deciding that jurisdictional question, we have to look at 2A, don't we?
I'm not aware of any authority that makes any exceptions to the idea that the appellate court is limited to the argument of the parties. There are certainly cases where the court can sua sponte raise issues if there's a lack of jurisdiction.
But what it would be doing here, let me think this through, we would be finding that the court lacked jurisdiction to convict of criminal restraint, not because it really lacked jurisdiction, but because the defendant didn't argue the basis for jurisdiction. That's the position you're proposing.
That the state didn't argue the basis for jurisdiction.
The state, yeah, I'm sorry.
Yes, I'm arguing that if you agree with Judge Green's position in this case that substantially interfering with somebody's liberty is not an element that's in kidnapping, that the appropriate decision for this court is to say that criminal restraint was not a lesser included offense as argued in this case. That's this case. It's very typical for this court to issue decisions based on the arguments before it and leave for another day. Is it a lesser under that other subsection?
I agree with you. That's very often the case when we're talking about points of law. But we can raise jurisdiction sui sponte. In fact, we've charged ourselves with the responsibility to question jurisdiction on our own. And when we do that, we do a de novo review. And so I don't understand how your argument of we can't apply a jurisdictional statute, and we only have appeal jurisdiction based on what the statutes say. So I don't understand how we can ignore that we have jurisdiction, regardless of what the arguments are, if we're sui sponte making that review.
I'm certainly aware and familiar with the precedent that the court can question. If it has a question about its jurisdiction, it can sort of bring that up sua sponte. You're sort of proposing the converse of that, I suppose, which is that even if the parties don't really establish jurisdiction, that the court could reach out and reach past the parties' arguments to attempt to establish its own jurisdiction, whether it's the Court of Appeals or this court. And I'm not familiar with that precedent, Your Honor. That would be new if that's the court's ruling in this case, that regardless of how the parties frame the issue regarding some legal argument, that this court can go outside it if it's just related to jurisdiction. I'm not familiar with any case law, and certainly the state hasn't cited any case law to support that theory. So
We often are more expansive when we're reviewing a Court of Appeals decision. I mean, we sometimes say, even though that wasn't argued by the parties, it's in the Court of Appeals decision, so we have to address it in some way. So your suggestion would be that what we would have to do is say that Judge Atchison erred by reaching out to an argument that was not made? Or do you think we cannot address it since it is in a part of one of the three decisions?
Your Honor, I think this court has recently made it pretty clear, just because it's in the Court of Appeals decision doesn't put it before this court, for example, that it has to be raised in a petition for review.
You think the state needed to?
I mean, Judge
by-
Atchison was a dissenting opinion, so
Right.
there's nobody
No, he was a concurring opinion.
concurring opinion. Yeah. Well, certainly this court has said that the failure to raise it in a petition for review, doesn't bring it before this court.
That cuts against you because
It could.
the failure to argue the issue was not an issue on the petition for review. In other words, any error that Judge Atchison made in his concurring and reaching out wasn't included in the
In my petition
points
for review.
points of error by the Court of Appeals. So that sort of strikes against you, doesn't it?
Yeah, I think it does strike against me. And yet, there's still no precedent for this idea. Judge Atchison doesn't cite, and certainly the state does not cite any case where this court has applied the subsection 2A idea to kidnapping.
Not
And-
with respect to that specifically, but there have been cases, and what comes to mind is State versus Kahn, in which the state argued search incident to arrest was the exception applicable, and on review, this court said no, that wasn't the case, but there was probable cause with exigent circumstances, so they upheld, and that was providing the state's argument when it wasn't made in the briefs, either before the Court of Appeals or on review. So we do have precedent for having done that.
For getting to another issue that
No. Another
basis.
means of resolving the issue that is raised.
That's
See,
not-
a
that's
big
not raised by the
distinction.
parties.
Yeah.
And it was a non-jurisdictional issue.
Yeah.
the court knows I'm in favor usually a lot of times of getting to issues.
This is the reverse
I
setup.
feel like I'm on the wrong side of that issue most of the time. So I'm in a sort of positional conflict here in some ways because
And you're not arguing
I'm-
for us to be consistent, are you?
on the point of whether or not there's a case law on kidnapping in this case, we do not have any case law in that regard. And for example, the court didn't reach out in Widget and try to decide whether or not interference with parental custody might be a lesser under 2A. And so to the extent that kidnapping is this broader doctrine, we don't have any explanation from the court about how that applies in other cases and in other doctrines. I mean, there's other interesting places where we have common law crimes like rape, but this court has resisted applying that common law lesser degree of the same crime analysis to other crimes. So that's where we're sort of at in this case. So, like I said, I don't have a lot to add to the actual decision, but
If we are looking at just the elements test, there were a couple of things with Judge Green's dissent that bothered me a little bit. It seems to me that putting a child in a duffel bag, even if the child's too young to resist, involves an element of force. And I understood him to say, you know, that there wasn't any evidence of force here.
Oh, I don't think that's what he said at all. I don't think he said there was insufficient evidence to support a kidnapping conviction. And he said there's clearly sufficient evidence to support a criminal restraint. It's not a sufficiency issue. It's just whether or not substantial interference with a person's liberty is an element of kidnapping. And if it is, then again, this court needs to say that clearly so that we start instructing juries on that in kidnapping cases.
Well,
and if it's
he
not,
was saying that the words are different, so they aren't identical. But and one of the arguments he made was that you could have a criminal restraint without the elements of kidnapping, like a brainwashing or hypnosis. But I don't understand why those aren't deception. You know, one of the elements of kidnapping is by deception, and brainwashing or hypnosis would be a form of deception. And so the problem we get is when we require identical words for identical, even though they're identical concepts.
well, I wrote the issue based on Schoonover, on the idea that if the lesser has, and based on Widget, where this court says, I mean, it's not just enough to be similar. This court has said identical. And so the question under B2 is substantial interference with a person's liberty identical with what's the confinement that's required for kidnapping? If it is, again, we don't instruct juries that way right now. And that would be useful law to know.
Any further presentation, counsel?
Yeah.
Any further questions? Thank you, counsel.
Please, the court, I'm Don Scott, Seward County Attorney for the appellee. If I understood Judge Green's dissent, it was based on the strict elements test that we set out in Schoonover to finally resolve that multiplicity question. And Judge Busser and Judge Atchison said it way better than I can possibly say it. But if we don't include criminal restraint as a lesser included of kidnapping, then it would be possible to convict somebody of kidnapping and criminal restraint, which that smells like multiplicity to me. It's the same act, it's just a different intent.
Sort of like convicting of possession of the paraphernalia or the components that are necessary for meth manufacturing and manufacturing of meth. We've allowed that.
Yes, but under that elements test, and if you're gonna take Judge Green's position on the strict elements test, you're almost going to have identical wording as opposed to concepts.
Well, you can get there if you look at the language that says lesser degree of the same crime. That was in a time when there were a lot of crimes that had first-degree kidnapping, second-degree kidnapping, that sort of thing, and that the intent was that it had to be one of those that designated the same crime but different degrees, and we don't have that designation here.
No, but you do have in the statute that a lesser included is a lesser degree of the same crime.
And would you agree that the state did not argue that? Or did not set that up as a reason that it was the lesser included?
I would agree with, we didn't argue that. In our brief, we took the precedents, the cases that had said that criminal restraint's a lesser degree of kidnapping, and left it at that. And if you were to stack up the arguments that I haven't made, it would make a pretty substantial pile. Another way to think about this is I don't think you can kidnap somebody without committing the crime of criminal restraint.
But we did away with that a long time ago, with the Fike tests were necessarily proved. That was the old rule. If you necessarily prove this crime while you're proving the other one, then you've got a lesser. And the legislature, or at least the courts, have interpreted the legislative amendments as doing away with the second part of the Fike test, or whatever it was.
But I don't think it's a useless concept anymore. I mean, it makes sense.
Oh, it makes all kinds of sense, but we're dealing with the law.
Right. Anyway, I would urge you to affirm the Court of Appeals decision, whether you use Judge Busser's kind of common sense approach that substantially interfere with a person's liberty is the same thing as take and confine, or whether you take Judge Atchinson's position that it's a lesser degree of the same crime.
Any further presentation?
No,
Do we have any more questions of council? Thank you, council.
thank you.
I don't have anything else, Your Honor.
Anybody have any questions? I see none. Thank you. Thank you both for your arguments this morning. Court will take this matter under advisement. Now turn